morning, Your Honors. May it please the Court? My name is Kurt Davis, and I represent the appellant in this case, Strategic Land and Property Sales, LLC. I'll refer to Strategic as Strategic, if you don't mind. And just in terms of time management, we have a cross appeal as well, so I'd like to reserve half of my time to respond to the cross appeal and any rebuttal, if possible.
Okay.
Let me start off with the facts in this case. Very, very simple with respect to our appeal. Strategic is a qualified real estate brokerage in Florida, and its qualifying broker is Ronald Carpenter. The appellee in this case, Mr. Donnelly, is a licensed Florida real estate associate, sales associate, and under Florida law, Chapter 475, in order for a sales associate to engage in real estate activity, he or she has to do it under a broker. And in order to do that, Mr. Donnelly joined Strategic in 2009 and remained there until March 10th of 2013. During that period of time, the qualifying broker, Ronald Carpenter, initiated the process of selling some property, which we refer to as the Allen property. It was owned by the Allen family. Selling the Allen property to a home builder known as Taylor Morrison Homes of Florida. During that time, Taylor Morrison agreed to pay Strategic 2% commission for the sale of that. Following the date that Mr. Donnelly left Strategic, March 10th, 2013, he went to a new brokerage, Cohen Commercial, on the 11th of March, the very next day. After he left, the terms and conditions of that sale of the Allen property took place and were negotiated, and ultimately a contract was entered into. 2 years later, that contract closed, and Taylor Morrison paid Strategic the 2% commission, which was $66,000. Following that period, Mr. Donnelly filed a lawsuit against my client to recover or to obtain that either the entire $66,000 or some part of it, claiming that he was responsible for that sale. When Strategic was sued, we denied that Mr. Donnelly was entitled to any portion of that commission, and also asserted about 15 affirmative defenses, 2 of which included an affirmative defense under Chapter 475.42D of the Florida statutes, which states that a sales associate may not commence or maintain a lawsuit against anyone other than his or her broker at the time the services were performed, which would entitle that sales associate to a commission. We also asserted an affirmative defense under Florida Administrative Code 61J2-6.006, which states that a sales associate may only work for one broker at a time. After a bench trial and some testimony from both Mr. Carpenter and Mr. Donnelly, the court made a factual finding that Mr. Donnelly, in fact, did terminate his employment with Strategic on March 10th of 2013. He became employed by Commercial Cohen Real Estate Group the following day. And most importantly, the court determined that the essential terms and conditions of the agreement for the Allen purchase and sale agreement were negotiated and came to a conclusion after Mr. Donnelly left the employment of Strategic. Now, Mr. Donnelly states that he was the procuring cause of that sale. He apparently did work after he left Strategic, and the court did find that he was the procuring cause of that sale, but it happened while he was under the employment of a different broker. Now, nevertheless, the court decided to enter judgment in his favor anyway for 50% of the commission, stating that he was entitled to, quote, a reasonable quantum merit fee thereof. We filed an appeal, obviously, in this case, And our argument is quite simple. Given the fact that the court made a finding of fact that this effort, this work was done after he left Strategic and was employed with another broker, he was statutorily barred from maintaining this action against Strategic. I won't get too much into Mr. Donnelly's arguments, but I do want to raise a couple of things first. Mr. Donnelly does not address this issue at all in his answer brief. What Mr. Donnelly does is he says, well, the lower court really made an error. The lower court didn't mean to say that his work was done after he left Strategic. He really meant before. And actually the phrase that Judge Barbas used was, the work was done subsequent to leaving Strategic. And Mr. Donnelly's argument is, well, when he said subsequent, he really meant before. To which we would, of course, respond that subsequent is not a very difficult word to understand. Judge Barbas has been on the bench for over 20 years. I don't think he's going to mistake a word like subsequent. It's used all the time. And the other point is that even if the lower tribunal said his work was done before he left Strategic, even if that were the case, we had another affirmative defense that said, and Mr. Donnelly's claim was solely for unjust enrichment. While he was with Strategic, he had a contract, an employment contract. And our argument is that under the case of Corn v. Greco in this district, that you're absolutely barred from bringing a claim for unjust enrichment while there's a written contract in place. And so he would have had to have brought a claim for a breach of contract rather than unjust enrichment. And we also, as I said, raised that as an affirmative defense. So either way, if his actions were before he left, his unjust enrichment claim was barred. And as the lower court determined, his actions were done after he left, he was statutorily barred under 475.42D from bringing this action. And Your Honors, if you have any questions, I'll be happy to answer them. Otherwise, I'm happy to take a seat at this point.
Okay.
Okay.
Thank you.
Good morning, Your Honors, and may it please the Court. Deneen Waslick for Appellate and Cross Appellant David Donnelly. I'd like to reserve 2 minutes for rebuttal on the cross appeal, if I may. Thank you, Your Honors. In this real estate commission dispute, Your Honors, the trial court correctly found that Mr. Donnelly was the procuring cause of the Allen property while he was employed by Strategic, but incorrectly applied the unpled procuring cause analysis to the counterclaim filed by Strategic to find that was the procuring cause of the bronze sale. We asked that the court uphold the judgment for Mr. Donnelly because the whole issue of the word subsequent was never actually raised below on rehearing or at closing argument or at any point. And the court's findings on the issue of Mr. Donnelly being the procuring cause on unjust enrichment were supported by the competent and substantial evidence in the record. We set out that evidence in our brief at 18, and so I just asked that the court look at all the evidence that Mr. Donnelly procured the sale while he was employed by Strategic. As to the pleaded affirmative defenses, we believe that the claim was actually very clearly made as unjust enrichment, and those issues do not apply. As far as the statute, the 475.42D is concerned, the cause of action is for monies that were procured and therefore Mr. Donnelly became entitled to while he was employed by Strategic, so that statute is met. However, the unjust enrichment did not occur until he was no longer employed by Strategic, and that's why it is an unjust enrichment claim and not a breach of contract claim, because the monies there was a long tail on this deal. It didn't close until well after he was no longer there, but based upon the facts that were presented at trial, and especially as set out in our brief at 18, it was very clear that Mr. Donnelly's efforts got the parties to the table, and they were just working out minor details and the timeline after he had left. On our cross appeal, our argument is that the parties the plaintiff Strategic changed its entire theory of the case in its closing argument, and did so over proper objection in closing. That objection is at least twice in the record, once in questioning and argument at I want to say 690 in the record, and also in the closing argument at 710 to 713, where we said, wait a second, you never pled procuring cause as a cause of action in your complaint. We went through all the breaches of contract that were pled in your complaint, and you haven't proved any of them here. We recognize that a motion for leave to amend the complaint to conform to the evidence was made, but it was not ruled on, and so therefore that issue is waived. Moreover, their argument is not really factually supported and set out in the initial brief at 22 is all the citations to the record about how the parties came together, generally before Strategic was even in the picture, and also that there is the testimony that the sale did not actually happen, it was not actually triggered, it did not really come together until after Mr. Braun Sr. died, and that was well after Mr. Donnelly had left the employ of Strategic. The court specifically ruled that there was not improper competition at play here. We note that in our initial brief, in our appellant's brief at 24. And so for all of those reasons, we believe that the trial court's ruling on the issue that we're appealing, that Strategic was the, quote, procuring cause in this case, is not supported by the record or the pleadings and should not be upheld here. Does the court have any questions about the pleadings here? Nope. Okay, then I'll just cede the rest of my time for rebuttal. Thank you.
I'd first like to address the rebuttal with respect to our appeal. Mr. Donnelly's counsel states that, well, there was evidence that he did actually do the work on the Allen transaction before he left the employment of Strategic. Essentially what Mr. Donnelly is trying to do here is trying to disturb the findings of fact of a lower tribunal, and it's black letter law that the findings of fact should not be disturbed unless they're clearly erroneous, and the test for that is, of course, whether there was competent substantial evidence to support the trial court's finding. In this case there was, number one, which we've cited to the record in our reply. Number two, Mr. Donnelly has never raised on appeal that the lower tribunal, that its findings of fact are clearly erroneous with respect to the timing of when that work was done on the Allen transaction. So that finding of fact cannot be disturbed. And as a result of that, we run straight into Chapter 475.42D, which says if you do work when you're not employed by a broker, you can't sue that broker. And that's exactly what happened here. And so that aspect of the final judgment should be overturned, and judgment should be in favor of Strategic, finding that it owes nothing to Mr. Donnelly. With respect to the cross appeal, Mr. Donnelly claims a couple of things here, and the main issue or the main point that Mr. Donnelly takes issue with is he says, well, the Strategic changed its cause of action at some point during the closing argument, and that's simply not true. What happened during closing argument is reference was made to the contract between the two parties, which is what Strategic sued or countersued Mr. Donnelly for. And in that contract, it specifically says that Mr. Donnelly is obligated to procure to procure real estate sales for strategic. Mr. Donnelly has seized on that phrase and said, aha, they've changed their cause of action to procuring cause, which is, there's some case law out there.
Well, but the trial court used that phraseology too.
It did, you're correct.
That was the trial court's whole focus, I think, with respect to all of these pieces of property, is the trial court looked at who do I think was responsible for making this sale happen, and it awarded commissions accordingly.
I think you're correct in that the trial court did, in fact, you are correct that the trial court used the phrase procuring cause, referred to Mr. Donnelly as the procuring cause of something. But strategic did not change its cause of action, and in fact, if you look at the court's ruling, it says something to the effect that Mr. Donnelly was the procuring cause of this sale. He left to go to a different brokerage to get a better commission split, and therefore that's a breach of contract. So he couched...
Did the trial court use that word? Breach of contract?
Yes, Your Honor.
Okay, because what was the breach?
The breach was, well, Your Honor, when we went into the trial...
What breach did the trial court find? Because I'm not remembering. I think I do remember the trial court saying there was a breach, but not identifying what the breach was. I may be misremembering that.
Your Honor, if I may, when we went into the trial, there was this concern that was raised by Mr. Donnelly's counsel that we hadn't adequately pled the breach of contract. Now, the complaint referenced this Braun transaction, which is the subject of the counterclaim. It specifically referenced it. It specifically said he worked on that and then moved to a different brokerage to get a better commission. We went into the trial, and I had an exchange with the court, and I said, Your Honor, and I'm citing from the record, Your Honor, just for the record, there are a number of claims at the complaint which we are not going forward with. This was obviously drafted a year or two ago, and during discovery, we determined what was relevant and what wasn't. And then I go on, and as you know, our main point is that Donnelly breached the terms of the contract with Strategic because he tried to procure the sale of these properties under Strategic, and then right before they were ready to go under contract, he left to seek a much larger commission. But I would like to go forward with the evidence. The court
Okay,
said,
so which provision of the contract did that breach?
That breached his obligation to procure real estate sales for Strategic. And I don't have
Well,
this.
but you just said he did all that and procured it while he was at Strategic.
He
But
did.
your problem is, he did all this work, you know, he did everything to procure the sale, and then, on the cusp of it being final, he went to another brokerage to get a larger commission.
That's correct, Your Honor. He would have gotten a 50% commission while with Strategic. And Mr. Donnelly testified, that's the whole reason I left, was to get a bigger cut.
Okay, okay, so tell me again which provision that breached.
Well, would you like the specific
Well,
section of the
I mean, you
contract?
said it breached the provision that he's supposed to procure sales for Strategic. Well, he was doing that.
Well, Your Honor...
But then he left.
Your Honor, it's kind of a cute way of going about it for Mr. Donnelly, which is, I'm going to do all the work, stay with Strategic, and right when the benefit comes back to Strategic, I'm going to skip over here and grab it for myself. And so Strategic doesn't get it. And we go into this a bit in our brief, which is, there's a covenant of good faith and fair dealing with a contract. You can't do that. You can't take all those benefits for yourself just by saying, I hereby terminate and move on. And so the lower court rightly said, that is a breach of contract. But it wasn't.
The lower court really was looking at it more as an equitable remedy under unjust enrichment as opposed to a breach of contract.
Well, the court literally said that is a breach of contract.
Yeah, I know, but again, you still haven't been able to identify a specific provision, and now you're relying on good faith and fair dealing, which has to be linked to the performance of a specific provision, and I don't think I've heard you identify the provision that you think was breached.
Your Honor, if I may, I can get Well, Exhibit 3 that was submitted to the trial court was the independent contractor agreement, and Section 2 of it talks about his responsibilities. Section 2 states that it defines the associate's responsibilities. It says, associate will use his or her best efforts to procure real estate-related business for broker. And again, the broker got no benefit from this transaction. Ultimately, the broker is trying to get a commission. It doesn't do the broker any benefit to procure real estate between these two third parties. They benefited, sure. But all of that work that was done with Strategic was for naught when Mr. Donnelly said, goodbye, I'm getting a bigger cut.
Okay.
But as I was indicating before, going down the road of procuring cause, that is kind of a straw man here. That's not what we did. We simply referenced Section 2 saying Mr. Donnelly had an obligation to procure real estate business for Strategic. And I think I have nothing further unless Your Honors have any questions.
Thank you, Mr. Davis.
Thank you.
Thank you, Your Honors. I think Judge Kelly has really honed in on the issue here, which is the argument was to bring the judge down the primrose path of this equitable procuring cause on the counterclaim. All the case law that was cited in that argument were unjust enrichment procuring cause cases by Strategic in that argument. And we immediately objected to that in the record at 710 and said, wait a second, that's not the theory that was pled. And if you look at the counterclaim, which the relevant parts start on page 22 of the record, they set out the provisions of the contract that they are alleging were breached on page 22 and 23, and none of them are the notion that you need to procure, use your best efforts to procure during that time period. And in any event, the trial court held that there was no improper competition, that he was working for Strategic when he was working for Strategic and not working for anyone other than Strategic. So, I agree that the trial court's language is a little bit mixed up, but at the end of the day, we brought to the court's attention that that procuring cause argument was not pleaded, was not tried by consent, and was not a proper basis for a holding, and the trial court basically ruled on that in any event. So we do believe that it was error to make that argument. And unless the court has any other questions, I'll rest on that and our briefs. Thank you very much.
Thank you both very much.